presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only and is not legal advice. This information is not intended to create, and receipt of it does not constitute an attorney-client relationship. The participants should not act upon this information without seeking professional counsel. The material discussed during this webinar should not be construed as legal advice or legal opinion of specific facts or circumstances. The content is intended for general informational purposes only, and you are urged to consult a lawyer concerning your own legal situation or any specific legal questions you may have. Any tax information or written tax advice contained herein, including any attachments, is not intended to be and cannot be used by a taxpayer for the purpose of avoiding any tax penalties that may be imposed on the taxpayer. At this time, I'd like to turn today's program over to Ron Lipinski, partner at Seyfarth Shaw, LLP. Ron, you may begin.
Good afternoon. I'm here with Jay Carl, and we're going to talk about discovery of social media. We're presenting this on behalf of the Seventh Circuit e-Discovery Pilot Program. For those of you who haven't, a good place to get resources for electronic discovery in general, but also in connection with social media, is at the website for the Seventh Circuit e-Discovery Pilot Program, which is at www.discoverypilot.com. E-Discovery Pilot Program started in May of 2009 and has promulgated principles which are similar in style and format to those of the Sedona Conference. Those are available on the website as well as other resources. Today our topic is to talk about discovery of social media, which is certainly a topic that's on everybody's mind. I noted yesterday that the Illinois State Bar Association's magazine had its front cover advertising and social media. There's been other programs for the Seventh Circuit on social media. Here we're going to talk about discovery and some general principles on preservation, collection, and admissibility. We're going to define it, talk about what it is. We're going to discuss discoverability, some methods and limitations on how you get it, where you get it. We're going to talk about some practical considerations for preservation, collection, production. And I think it's important to note that there are two ethical considerations, which obviously, since you're on the line, one of them is Rule 101, which says competence. In this day and age, social media is so prevalent that any lawyer who is litigating in any of the courts, I think, has to consider social media as a possible source of discovery and relevance. And so your competent representation requires that you have some knowledge about it. Diligence also asks you to act with reasonable diligence and competence in representing a client. So with those remarks, I'll introduce my colleague, Jake Carl, to talk about definition and scope.
Thank you, Ron, and good afternoon, everyone. This is Jay Carl. Before we dive into the nuts and bolts, I'm sure that everyone is familiar with social media content, your Facebook, your LinkedIn, and we're going to talk about the importance of it as a discovery target. But what kind of information does it really contain? Well, it's interactive, it's shared, it's dynamic, it's collaborative. People can tweet just their thoughts or their comments, their opinions. People can post pictures and videos on these sites. So it's important to recognize how ubiquitous social media has become. So I was doing some research on this and found a Pew Research paper that stated that 67% of online adults use social networking. And then 22% of Fortune 500 companies now have public-facing blogs. And we're going to talk a little bit later about the adoption of social media utilities by employers and other entities. But, this should be pretty much in everyone's playbook when it comes to, doing some, at least even the preliminary informal discovery, your preliminary investigation, with respect to your matter, whatever that matter may be. These social media websites, whether it's public content that you can look at without going through formal discovery, or even privately held content, it's important to recognize that it can contain some key information. many people are aware of social media, but a lot of people don't use it. So it's just important to understand the valuable information that can be there. It's also important to recognize that in the context of corporate litigation, civil litigation, that many employers are using social media websites, Facebook, Twitter accounts, and these may be accounts held by the organization, or in some circumstances could be basically the informal adoption of those utilities as a business tool through employees' personal accounts. So that raises some sticky discovery issues sometimes. So that really just want to instill that the importance of social media as a target in discovery.
Yeah, posts to social media can have various types of evidence. For example, there may be evidence relevant to a sexual harassment claim. In intellectual property disputes, you can find out whether there's been misappropriation. Sometimes you know whether there's been an investigation of violence in the workplace. It's there. Tort claims, a personal injury claimant may be shown to have inconsistent actions on their Facebook. So the targets and what might be posted is important. In terms of discoverability generally, but really social media, particularly since the 2006 amendments to the Federal Code of Civil Procedure, there really is no question that it is discoverable. I mean, the 2006 amendments made it clear that there really was no distinction between paper and hard copy documents and electronically stored information. It really has been pointed out in a case we've cited there, the Offenbach case, that scope of discovery into social media requires the application of basic discovery principles in a novel context. Namely, you need to define what you're looking for and how it might be used. Clearly, it was intended under the 2006 amendments to be included. Those definitions and those amendments were very expansive with the view that electronic data would change. And in fact, over the last 7 years since those amendments, social media in its various contexts has expanded. If you look through the rules, they are clearly addressable in Rule 26, Rule 16. Just talk about how you need to consider it. Rule 16 conferences, it certainly is one of the permissible things that need to be discussed and should be included in consideration. Rule 26 and 34 also talk about ESI, and again, those principles apply in the same manner to social media. When we're talking about discoverability, as in any situation where you're trying to decide what you need by way of discovery, the questions are always similar. Namely, is social media relevant to the claims and defenses at issue in your litigation? Again, you need to consider this because social media is so wide and vast that you want to spend some time thinking about your particular issues in your case. Also, is it within your possession, custody, or control, or is it in the potential possession, custody, or control of your opponents? And we're going to talk a bit more about that coming up here about what that means. And then finally, just as with other evidence, you need to think about whether there is something that might preclude or limit discovery of social media content. And we're going to talk about the Stored Communications Act as well as some other privacy issues which may come to play. When you are thinking about your case in discoverability, one of the issues that is present in both general electronic data, electronically stored information, and social media is it potentially relevant, and can you reasonably anticipate that it will be relevant to your case? If it is, it needs to be preserved, and there is significant challenges in preserving social media. You should note that if you are the plaintiff in a case, the obligation to preserve potentially relevant information is going to likely arise before you file the case. When you are engaged in investigation of your claims, you need to consider whether or not there is social media that might be potentially relevant and should be preserved. Those things are important and have become the subject of litigation recently. For example, there was a case just decided in New York last month where a claimant in a personal injury claim had, quote, gone in and cleaned up his site, deleted many things that were inconsistent with his claims, and that was subject to discovery, and it had a major effect on the litigation, including the award of attorney's fees, cost, and an adverse inference at trial. There are ethical considerations, obviously, for us attorneys, because Rule 3.4 says that we can't advise or assist in the destruction of potentially relevant evidence. Locking down a site is one potential way to preserve it. If you have the ability to do that, sometimes the best way to preserve social media evidence is to get a printout, although that's prohibitive sometimes because the amount of data that might be there is very, very large.
And one thing I just want to mention, Ron, is that the standard for the duty to preserve and when it's triggered, is the information potentially relevant? A party is obligated to take reasonable steps to preserve that information. And so with respect to social media content, you sometimes need to think creatively in terms of how is going to be the best way to preserve certain types of information. And really, it requires you to focus, and we'll discuss more about this, but it requires you to focus on really what is necessary to obtain from it. In certain circumstances, it can be content, probably more often than not content, but there are also other kinds of information associated with social media use that should fall within the scope of your thinking. And that could be, for instance, who accessed a certain site, when that site was accessed, from where the site was accessed. So a certain internet IP address, for instance, really might be a key piece of the information as opposed to the content of the communication, which is probably what everyone jumps to immediately. But in terms of thinking about what a preservation obligation may be and the reasonable steps you might need to take or that you may hold the other party to take, it's important to consider exactly what it is that falls within the scope of that potential relevance and what's key.
When we talk about relevance, it's dependent upon the facts and circumstances of each case. And sometimes that's very difficult to determine, particularly and especially early on. Sometimes you get to the Rule 16 conference and you're not quite sure whether social media or even electronically stored information is going to be relevant, but it should be on everybody's initial checklist. You need to give it some consideration, just like email or data processing or Word files, loose files. Social media could be potentially relevant, and it depends on the circumstances. For example, the content. And social media generally has two types of content. There's usually a public space, which can be accessed by anyone who is a member of Facebook or LinkedIn, et cetera. And there's also a private space. And getting to the private space is the challenge sometimes that needs to be followed, and it has broad ethical considerations on how you get there. Sometimes the key information is date and time contact was added, who added it, who has access to the wall, identity of individuals in the subject's network. Sometimes it's very helpful to know whether a potential witness has a direct connection to a claimant or a defendant in the case. Deleted content is also important. Other things that always seem to surface are, in many of these litigations, is an attempt to find out the name. Anonymous posters have a lot of protection under the privacy laws and federal statutes, and getting to know who the poster is and what their identity is and what their IPI address is sometimes as much of a challenge as anything else.
So in addition to considering, really what's at issue and what kind of information is relevant or key, you also need to consider whether or not the information is actually in the possession, custody, or control of either your opponent or your client. And so we thought we'd spend a few minutes on possession, custody, or control and really what that means. So if the information is in your possession, custody, or control, you may be on the hook to have to preserve the information and potentially produce it in discovery. And really, it's important to recognize those terms are in the disjunctive. And the key operative language here is control. Now, this comes up, more often than not, like in the context of an employer-employee relationship. For instance, an employer that sanctions or otherwise kind of implicitly allows their employees to use social media as a business tool, for instance, if the entity is involved in litigation, could that entity be said to be in control of the social media content? And could the entity be compelled to disclose social media content of one of their employers or of one of their employees in the course of a litigation? So how might that be analyzed? Really, the tests are whether or not you have a legal right to the information. That is there a contract, some sort of agreement, a statute, a regulation, or any other kind of legal entitlement that might give you basically the ability to obtain it? Could you enforce those rights? Other jurisdictions look to a test called the practical ability test, and this is a little bit broader. But really what this is focused on is, could you reasonably expect to receive the information if you asked for it? So in Illinois, I believe, is a legal right test, but you should also consider, even if you don't have a legal right to the information, the idea, the concept behind the practical ability test is, primarily that you don't hide behind the control factor. If you know that information exists out there, you could take steps to preserve it if it was going to be destroyed, and hide behind the control factor. So you just may want to consider, what reasonable steps you may be able to take to preserve and potentially obtain information. If you could just ask for it and reasonably expect to get it.
Let me interrupt here. We are getting several questions here, some of which I'm not so sure we're going to be able to answer as we go along here, but they are all going to be recorded, and we will do our best to respond via email within the next couple of days. I mean, we've already had probably a couple dozen questions, so keep them coming. We appreciate them, and we will do our best to respond. We may do some orally here if we have time, but otherwise they will all be recorded, and we will respond via email. So that if you've decided that you need to look at social media, I guess the way to go about it is first, often informal discovery is probably as effective sometimes as anything else. And it's interesting in that when I started practicing a few years ago, actually 30 plus, we didn't know about these kind of things. And I will tell you that in about an hour on the internet right now, you can find out more about your opponent than sometimes we would ever discover in the course of regular discovery back when. So informal discovery is a good place to start. When you are doing informal discovery, you investigate public profiles. There are internet and social media sites. By definition, public profiles and public sites are available information that can be uncovered without needing to expressly get permission and to contact the individual who's done the posting. Sometimes a user's posting will list friends, shared photos, videos, and other valuable information, and it's publicly available. We're going to talk about them later, but there are tools available which will crawl public websites and download changes and new content, and that sometimes is a good thing to do depending on the facts and circumstances of your case. Informal discovery limitations. There are clearly ethical prohibitions about what you do in informal discovery. I mean, in general, public information is fine, but using subterfuge or such as a friending, where the person friending somehow gets access to the private sites of either a witness or another party, can be and has been found in several circumstances to violate the ethical rules. They violate the rules against contacting someone you know to be represented by attorneys. They also implicate the situation where attorneys are barred from perpetrating a fraud. And if you access a site through a subterfuge without disclosing the reasons for it, that's been held to constitute a violation of the ethical rules. And we cite the San Diego Bar Association Legal Ethics opinion. Philadelphia has one. New York has one. The New York one recently, they described the situation like this. If a stranger made an unsolicited face-to-face request to a potential witness for permission to enter a witness's home, view the witness's photographs and video files, learn the witness's relationship status, religious views, date of birth, and review the witness's personal diary, that witness almost certainly would slam the door and perhaps call the police. On the other hand, in contrast, in the virtual world, a stranger who gains access to the site may in fact be able to view all of that individual personal information without any feathers and do it in a virtual website. That's the contrast there. And if you are going to get access to a personal site, you need to do it in a more formalized way and subject to court supervision, et cetera. Another situation that has come up is obtaining access through perceived coercion. In the Hillstone Restaurant Group case, there was a situation where an employer learned that employees may be engaged in some type of organizational activity, and disgruntled employees were meeting to talk about it. They gained access to the blog by getting a user ID and password from another employee. They sought to use those, the information gained, and in a court, the jury found that the employee had not voluntarily allowed access, that they'd been coerced into it, and this constituted a violation of the Stored Communications Act. So coercion is another situation that may prevent you from getting access. The other thing to remember, again, is that attorneys are ultimately responsible for the actions of anyone that accesses a site. So if you have an agent, a paralegal, investigator working for you, use subterfuge to get into a site, an attorney could be held liable under the ethical rules for violations relating to fraud, as well as potentially contact with a witness that you know, or a party that you know to be represented by counsel. At this time, we're also going to give you information. We have applied for CLE credit for this webinar. You need to write down the following code on CLE attendance information form, which is going to be emailed to you. So an email will come to you with the CLE attendance affirmation form. It'll be sent out next week. You need to write down this code, SS2275. This is the only time we're going to repeat it. Please write it down. Code is SS2275. You need that on a form if you're going to seek CLE credit for listening and participating in the program.
So, as far as the mechanics of actually obtaining social media content are concerned, it's important to consider and to investigate the Stored Communications Act. So the Stored Communications Act was enacted in 1986 as part of the Electronic Communications Privacy Act. Now it's a complicated statute, and I'm We could spend an entire hour going over the Stored Communications Act today. The most important thing to recognize is that it imposes different levels of restriction on the ability for both the government and in civil private litigation to obtain private and, in some circumstances, non-content related information from internet service providers, the ISPs, for instance, Facebook, Yahoo, Hotmail, etc. So really, the restrictions are broken up into two tiers. Whether or not the entity or the ISP falls under something called an electronic communication service provider or a remote computing service provider. And basically we can discuss a little bit the distinctions between them. And although there are varying court decisions on this, generally speaking, electronic communication service provider, an entity or an ISP would fall into that category. For instance, if you send an email and to say it's yahoo.com and it's sitting there in the inbox and unopened. So basically the entity is providing the ability to send or receive wire or electronic communication. Once that email, for example, is opened and it's sitting there and it's being stored on the site, then that ISP might be categorized as a remote computing service provider in that it's storing electronically stored information. And you may have also heard the term cloud computing. So there are many cloud computing service providers out there that offer, for example, storage. Google Drive, for instance, or Dropbox could fall into the remote computing service provider category, for instance, in that they are online service providers used to store electronically stored information. So there's different levels of restrictions that apply in terms of the ability to obtain the information to basically for both the compelled and voluntary production of information by ISPs. So from like a governmental entity perspective or from the government, there's basically a series of, they either have to issue a warrant or in certain circumstances a court order in order to compel the ISP to produce information. And the level of procedure that needs to go through, that the government would need to go through, is dependent on whether or not it's an ECA or electronic communication service provider or a remote computing service provider. In addition, it gets a little bit more complicated in that there are different kinds of content. So there is basically the content of an email communication, and then there is also non-content information. This might be the identity, for example, of a subscriber. It might be, for instance, timestamps of when a certain subscriber or customer accessed the site. So there's different levels of procedure that need to be followed in order to obtain information from an ISP based on the Stored Communications Act. Now, the Stored Communications Act does apply also in the context of civil litigation. So in O'Grady, basically, the court struck down a subpoena to an email service provider of a web journal because of the SCA. They were looking for the ISP, the Internet Service Provider, to basically turn over the content of email communications. And under the SCA, basically the ISP is prohibited from turning over that private content without either the consent of the subscriber, for instance, and there are certain other types of exceptions, for instance, in the case of child abuse or other kind of public policy reasons. But generally, in order for the ISP to turn that information over, that private content, they would need to have consent from the subscriber in order to do that. And in Crispin, the court found portions of an individual's social networking sites designated as private to be secure information under the SCA. So earlier I made the distinction between content-based information and non-content-based information. So for instance, the content of an email, a subpoena in the civil context would not be necessarily an appropriate means by which to obtain the information. However, if you are after, for instance, the identity of a subscriber or the IP addresses that were used to access a site, for instance, that may be non-content related information. And under the SCA, an ISP in the civil context, a subpoena would be an appropriate tool, I believe, to obtain that information. So generally speaking, it's just important to recognize that you need to look at the Stored Communications Act based on your circumstance. There's different ways that you can go about it. And as Ron will talk about it, one of the most effective ways of obtaining information from an ISP or social media content really is just to follow the normal discovery tools. For instance, interrogatories and document requests, specifically document requests to the other side, are often the best way to obtain content, private content that may be stored by your adversary, in the context of a litigation. If another avenue, and certain court cases have gone this way, is that a court, for instance, could compel a subscriber to give a consent to the ISP in order to disclose the information, so that the ISP can be in compliance with the Stored Communications Act. So that's the general mechanics of the SCA, and it's just really important to be aware of it. And as I mentioned earlier, the SCA is very complicated, and there's several different tiers of disclosure. And there is a very good guide. It's called a User's Guide to the Stored Communications Act and a Legislator's Guide to Amending it. It's a law review article authored by Orrin S. Kerr. And if you are interested in learning the details and behind the SCA in great detail, as I mentioned, we could spend a whole hour on it. I would highly recommend that law review article.
The situation that also comes up is whether or not sending a letter of preservation to a ISP is sufficient, and there's been some court decisions, particularly one out of Massachusetts, which has said that a letter to an ISP about preservation is insufficient. We have some situations where a subpoena directed to an ISP has been enforced to the extent to allow or compel the ISP to preserve information. So subpoenas have been used for preservation purposes, but they've not been enforced to require an ISP to divulge content of communications, only to preserve them. One of the drawbacks there is that you got to make sure the courts have jurisdiction over the ISPs, and a lot of times the litigation with ISPs happens either in California or Virginia. Virginia seems to be a site where many of them have locations. So jurisdiction is always an issue. If it's a lesser-known ISP, one of your challenges is going to be determining where a court has jurisdiction in order to either serve a subpoena or seek enforcement. In getting discovery in the situation, again, the situation we have here is that we're trying to use and should use interrogatories, document request, which is the usual forms of discovery. It's just in a new and different way of getting information. So the courts are willing to require users to produce social networking information in response to what's called a reasonably tailored discovery request. And that's one of the challenges. If you go to court and say, serve a request for document that says, give me everything in all of your social media accounts, you are going to have a difficult time to get it. Courts have been very aware of privacy issues. They've been very concerned with making a requester show that there is some reasonable basis for relevance and that the request is reasonably tailored to produce potentially relevant information. In the case we cite in our PowerPoint, the EOC versus Simply Storage Management, electronic copies of the claimant's profiles were required to be produced. It was a situation where the court acknowledged that, quote, discovery of social networking sites requires the application of basic discovery principles in a novel context. And so they required that these sites be produced. In another case, the Romano case, we talk about the defendant requested production of public and private content from the Facebook and MySpace accounts, and there was an objection. Plaintiff was ordered to provide defendant with access to the postings from media sites. So there have been situations where, as part of a review of such requests, courts have been entering orders where, for sort of in-camera review, some judges have received and have entered private spaces as a friend in order to examine the contents, in order to rule on a motion to compel. Other situations where your opposing party has been given access to one of these sites because of a demonstrated need to have active interaction with the site. All of these situations usually start with some interrogatory requests, production request, perhaps a viewing of a public site, because if you are going to seek information from a private site, you are going to need to support to a court that there is a demonstrated need, that the information is potentially relevant, and that the best and least expensive and most convenient way to do it is to get access. There are other issues, obviously, for preservation and determination of authenticity, but in general, start out with informal, progress to interrogatories and requests for production, and then from there you should be in a position to assess whether or not there is a need for further access in order to get relevant and potentially relevant information.
So I saw some questions on this earlier, and we'll try to address those questions if we have some time at the end. But this may hit on some of them, and that is, what often comes up is, is there an obligation to preserve and produce relevant social media content posted and communicated by an employee using a personal account? And this would come in the context of representing an employer, for instance. We talked about possession, custody, or control, and that's a key issue. So you need to analyze that issue, and these are highly fact-driven inquiries, and district courts may differ. So some courts may view such content as outside of an organization's possession, custody, or control. And again, in that context, it really depends on what test is being applied, the legal right test, the practical ability test. But the court may consider, several different factors in making that determination. For instance, could they reasonably expect to get it? Was it sanctioned? Was the employee required to create the account in order to complete their duties within the position? Other courts may require organizations to produce content using personal accounts. Now, there's a key issue here that I don't think has been addressed yet, and that is there's a number of new legislation being enacted by the states, which basically prevents, I believe, employers to compel their employees to give access or to turn over the usernames and passwords of their social media pages and related type of content. So how that new type of regulation would butt up against this context in litigation, and whether or not an organization is in control, if the organization, the employee, is held to be in control of the information, is compelled to produce it, how that may square with some of these new state laws that are being enacted, I think is something that has not yet been fully addressed. So that's an issue as well as to consider. Now, there's also some considerations with respect to employee privacy. Now here I want to talk a little bit about social media content that may not necessarily reside with a remote internet service provider. So as you know, as I'm sure many of you know, that simply by use of a computer to access certain sites, perhaps your personal email account or a social media site, that information regarding your visits, and in some cases, some of the content of a web page may actually be stored on the local computer that is being used to access that information. So what kinds of considerations are there if, for example, you find personal and private information, electronically stored information on a company computer? Are the privacy rights of the employee impacted by that? And I think it really also depends on the facts and circumstances. So in the Stengart case cited there, a company's retrieval of messages from a workplace laptop used by an employee to access her private password-protected web-based email account was found to violate the employee's expectation of privacy. Now, the company did have a policy, a computer use policy, but it did not address the personal use of web-based accounts. And the court found that the steps taken by the plaintiff to create a reasonable expectation, basically the steps taken by the plaintiff to create, password-protected accounts and to keep the information private created a reasonable expectation of privacy when communicating. And in this case, it happened to be communications with her attorney. Now, in other circumstances, depending on the scope of the organization's computer use policy and other factors, and what steps were maybe taken by an employee to secure the information, information fragmented on a hard drive, for instance, may not be private to the employee. In Holmes, for instance, the plaintiff had no expectation of privacy when sending personal emails using a company's email system. So it's just another consideration for everyone to be aware of with respect to employee privacy concerns, the use of social media, in the employment context.
This issue is getting bigger and bigger as more employees are bringing their own devices to work. The advent of smartphones and tablets really are blurring the lines between some social media sites, as whether they're personal sites, business sites, and the crossover. So all of these situations are highly fact-driven and are still developing, and all of these new changes in hardware and software, cloud computing, the Androids are making them very difficult to analyze. And again, you need to be very conscious of them, and it's fact-driven, requires some thoughtful consideration.
So, to kind of sum up, the mechanics, legal mechanics of actually obtaining social media content, I think is, it just really, you really need to consider what it is that you need. And what would be the best way to obtain the information? Or if you're on the hook to preserve it, what is the best way to preserve it? So, the focus here is what's reasonable under the circumstances. Ron talked about reasonably tailored document requests, and we think that that's extremely important. So spend some time thinking about what it is that you're you're actually trying to obtain or to preserve? Is it actual content? Do you really care about maybe not the content, but certain date stamps or access logs or users lists? And that's really going to inform the steps you take to obtain the information or to preserve it. Where will you go after the information? Will you actually seek to obtain information from Facebook or from the ISP? Should you try to obtain information that may be stored, fragmented information, or access logs that may be stored on a person's computer as opposed to the ISP? So, other things these are just things to consider when trying to determine an appropriate strategy to preserve or to obtain or potentially to produce the information. So in a few slides, we're actually going to talk about some tools that can actually be used to help preserve and collect social media content, web-based content. Obviously, there's how you go about doing it depends on the facts and circumstances. In some circumstances, and we'll talk about this, a screen print can be completely sufficient. In other circumstances, it may not. So there's many different options. There's no one-size-fits-all. But different kinds of tools exist out there. So it's just it's important to be aware that they do exist. And then again, proportionality considerations must be factored into your recommendations and your decisions, right? There's a request to produce, for instance, all social media content, including deleted content and so on and so forth. A very broad discovery request is likely not to be, proportional to the facts and circumstances.
When you go about trying to collect and use social media, one of the issues, of course, is chain of custody. And the use of personal accounts to access, preserve, collect puts the collector squarely in the chain of custody. So one of the things to consider, if you as an attorney get involved in the collection of social media, you've got to be concerned that you may become a witness and forced to testify about the method, means, et cetera, of collection. Another big issue is if you get the information from a media site, how are you going to authenticate it in order to use it in evidence? Some of the difficulties include you don't know, because it's dynamic, if it was completed at a given time. Content is edited by users at any time, sometimes lost to technical malfunctions. Collected data is very often not user-friendly. Sometimes collected social media data is altered merely by the fact that you're looking at it. It's difficult to interpret. Fields of information have different meanings. Date stamps, you can have several different date stamps on the same piece of data. Format of preservation, format of production, all of this is very dependent upon the data that is relevant. If you're going to seek to admit it, the usual in order to authenticate it, they're usually the usual questions, the 5 questions. How was the evidence collected? Where was the evidence collected? What types of evidence were collected? Who handled the evidence before it was collected? And when was it collected? Generally, in cases, particularly in light of the stress on cooperation, often the best way to get social media evidence is to get an admission or a stipulation with your opponent. Very often, a screenshot is all you're interested in. Sometimes, depending on the circumstances in your case, you can get an admission or a stipulation, and you're all set. If you can't get that, it's probably likely you're going to need an expert witness to come in and authenticate the site, talk about the particular social media site, what their policies are, who has access, who can create things, what's the access with the ID, and you may need to consider that if, in fact, the content of a social media site is very important in your case. Courts have been cautious when admitting social media. As I said before, sometimes judges have become online friends. They've allowed printed copies with date stamps, and sometimes they've used circumstantial evidence which require the creation of data to authenticate social media content. That very often will require a vendor with some expert testimony.
So production format. Again, I alluded to this earlier, but production format really turns on whether the receiving party needs to review the social media data interactively. So, I think in most circumstances, as I mentioned earlier, sometimes, a screen print may be sufficient as long as it can be properly authenticated, for instance, but it will basically communicate the content which is at issue. In other circumstances, if it's necessary to, based on the situation, to kind of, produce or otherwise demonstrate that the certain interactive components of the system, it may be that an opponent or the judge in certain circumstances could basically gain access to the site and actually view it online for an in-camera review, for instance. So it really depends on, the content of the information and what you're really needing to produce. The other factors to consider is, would it be, does it need to be reasonably searchable? So, for instance, if it's not just specific content of an email communication, for instance, or a Facebook posting, if it's access logs or something of that nature, it really depends on how that information is stored. It could be produced electronically in a delimited text file or perhaps in an Excel spreadsheet. So there's just different circumstances that will warrant different types of production formats. So there's really no one size fits all, but I think in most circumstances, typically, a certain kind of screenshot, can be sufficient, depending. There are, of course, other ways, and I'm going to talk a little bit about some of the preservation and collection tools that are available. So, there is no best solution for preserving and the formats of production for social media content. There are a variety of tools out there in the marketplace that purport to be able to collect, preserve social media content and offer different ways to produce it. So some of those tools will actually connect up to what is known as an API, or an application programming interface. And so, for instance, they could connect into Facebook, for instance, and basically download content. There are web crawling utilities, as Ron, I believe, mentioned earlier, that basically will scan websites and monitor for changes in those websites. And whatever is publicly hosted, any of those changes can be downloaded. Those programs may record, for instance, a timestamp with respect to when that information was downloaded. It may generate what is known as an MD5 hash, or a unique identifier for the content, and that is basically a fingerprint for that electronic document. It's also important to recognize that some social media sites have built into them specific methods by which information can be preserved. For instance, Twitter has a public follow feature that enables access to all the past tweets of a specific user, I believe up to 3,200 past tweets, and any new tweets in real time without generating a formal follow request. So, for instance, if you were to check out Twitter, you can implement this public follow feature, and you should be able to see the past 3,200 tweets, public tweets, of a particular user. Facebook also has a download your information utility, and this is important from a preservation context. And what that does is basically it's a utility that it allows the user to basically create a backup copy of their profile. And I believe that it basically compresses the information into a zip file that can be downloaded by that user. LinkedIn also has a print to PDF feature that allows the person to basically print certain content of their LinkedIn profile to PDF, and it puts a date stamp on it, for instance. All of these could be used, for instance, the Facebook Download Your Information utility could be used not only as a preservation function, but also as a way to produce the information. So generally, if you go out and you Google preservation collection tools for social media or cloud computing, you will find a variety of tools that are out there. I don't endorse any particular tool at all, but basically the point here is that there are a variety of different solutions out there that purport to automatically archive social media and website data with ultimate control, for instance. These are just quotes that I took directly off the web pages for these utilities. So, these are different types of tools that can be used to, collect, preserve information from social media websites. Key considerations when selecting a tool are, if you are an organization, for example, that uses multiple different social media sites, Facebook, Twitter, LinkedIn, and you want to identify a tool that will help you preserve information in a variety of different situations, it's important to consider what social media sites that solution will support. Some solutions will only support, for instance, Facebook and not others, or they don't do a good job with LinkedIn, but they do a good job with Twitter and Facebook, for instance. So how many collections can run simultaneously? Oftentimes the pricing structure might be built on how many different sites you need to monitor, how many sites you need to collect from or preserve. Ron talked about authenticity of the information. How does the vendor actually collect, or how does the tool actually collect and preserve the information? What is the process? You just want to make sure that you can basically authenticate the data, once it has been preserved. So another important consideration is once the information has been, downloaded, or if you're using one of these utilities, the content that can be gathered can be extremely voluminous. And this is just a problem that exists with electronically stored information generally, is the amount that's out there. And if you're using a tool to aggregate social media or website content, the actual number of pages and the content that can be stored can be tremendous. So does the tool offer the ability to search, I think is an important consideration.
All right, well, we've come to the end of the hour, and we, just to sum up, first we thank you all for logging on and listening. Social media is there. It's not going away. We believe it's something that needs to be considered in your analysis of discovery in any particular case at this time. We hope we've raised some issues for you. Again, informal discovery, interrogatories, requests for production are the way to go. After that, you hopefully may learn what you need. If not, you should have at least the information to go forward and see if there's a motion to compel or some other way to go. Admission stipulations are often the best way to get it in evidence. Vendors can do a lot for you, but again, cost, proportionality, and what do you do with the information is important. So, again, social media is here to stay. We hope we raised some issues. Thank you for listening.
Thank you very much. Have a good afternoon.
Thank you again for joining us today. This concludes today's web conference. You may now disconnect.